Welcome everyone to the Tonkin Legal Group, home of the Australian Family Law Podcast, the AFLP, definitely not the official podcast of the Australian Football League. It is I, as always, Joe, and today we have the privilege, Charlie. We've got Sinjin back on. How you doing, SH?
I'm well, thanks, Joe, and nice to be back. You guys did an excellent job last week in my absence, so let's hope we can fire it up again this week.
Absolutely. Charlie, good to see you as always.
Good to see you, Joe. Good to see you, SH, and good to see you, Sinjin, on the back of a Tigers win.
Yeah, I expect Joe to be wearing his Richmond gear this week. No, only kidding. Yeah, look, what a win, hey? What a win. A win, as McClure said on the podcast this morning, a win for the ages. I thought, nah, not quite. But look, I had the privilege of being there and to see Sam Lawler, Tasmania's next captain, bring the house down was awesome. So, no, I hope he's around for the Tigers for a very long time. He's played 18 games, and if that's what he's like after 18 games, then he's going to be a prospect.
And now there's going to be some form of handing over of the baton, I believe, after
yes.
So the Tigers have won, the Bombers lost.
That's right. And some viewers would remember when I had to take this a few weeks ago after
they'll remember
Bombers had won and knocked us off the second bottom down to the bottom. So yep. Joe, I'm now going to ceremoniously hand to you, with the greatest of delight and pleasure, the wooden spoon.
Magic!
Wow, how do we telepathic?
It's phenomenal.
Well done, Joe.
I call him Harry Van Hattem. Thank you very much. Thank you very much.
Looks like it lost a bit of size in travelling through space.
Yeah, there's we haven't quite nailed the art of transporting matter across it. Yeah, but look, the fact of the matter is, it's happened. It's here, and it's here to stay for this year. I can't see us winning another game this year unless, of course, Port Adelaide want to throw a spanner in the works in the last round. But that's
goodness.
It's not going to happen. We're gonna comfortably finish last, I think. And super result for your boys. Not quite so super for my boys, but look, we didn't lose as much as you thought we would last week, Charlie. So that's at least pretty good.
You didn't. I was pretty rough towards your Bombers. I think was it 88 points, my prediction.
Yeah, something like that. Yeah.
88. Yeah. So my apologies. I think it was a very tight 66-point game instead. So sorry about that.
Could have been a blowout, Joe. Could have been double that, really.
It could have been.
Oh, yeah. Imagine if Peter Wright didn't exist. Oh, mate, that would have been. That would have been bad.
Metros.
Yeah, big game from Dos Metros.
Oh.
Love Dos. He's a good man. Dos is a very good man. And yeah. Charlie, your big baby friend Christian is not a good man, and he's definitely crying at the moment because his boys could not get up against his old mob.
Nope. He's not a good man, the big baby Christian. So it was an absolute delight to see us beat Petrarca's Suns in our first game against him playing for them. So I don't think he troubled the scorers too much, just a measly 14 touches and a few whinges here and there from him, which we've come to expect. So it was a good win. I was a bit nervous. It was quite tight, a high scoring game. So I think we were talking earlier, Joe, the D's had the potential to lose every game from here in, and if we did that, we would have missed out on the top 10. So,
really?
It's possible that we could have. So we've actually got a pretty tough run home. So, good to win that game to ease my nerves a bit.
How was good Christian with Mr. Lombard this week?
I saw him hugging and laughing with him at training when the cameras were on. So he's good at putting on a bit of a show, my friend Christian. He didn't try and steal the ball off him again this weekend. But no doubt there'll be something he'll whinge about again soon.
And did I hear a whisper he wants out?
I heard whispers on the radio, but I don't know how substantial they are. But I'm going to run with it. I've heard he wants out.
He wants out and back to Melbourne.
But back to anyone who'll pay him more or wherever. He's a gun for hire, Christian.
He's a brand, isn't he? He's a brand unto himself.
Yes.
Petrarca brand.
You get a lifestyle with Petrarca. Yeah.
You do, yeah, the chef. Yeah, cooking up losses at the moment.
Yeah.
Well, speaking of looking to run away, speaking of people looking to run away, look, the theme of this episode is anyone thinking of running straight to court. Well, look, it's not quite as straightforward. Today's episode is going to be about the steps that you need to take before you can get to court. Everyone talks about, especially here in, this is obviously a family law podcast, and any other type of matters that you guys might be involved in. There's always the looming spectre of court and the threat of issuing proceedings. But as we're going to discuss here today, it's not quite so straightforward. We're going to be discussing about the steps that you need to take before you can get your matter to court. They are officially called the pre-action procedures, and this is what we're going to start with. As always, we only started it last week, with the rules of the game. Here we are, rules of the game. We're talking about the pre-action procedures, gentlemen. SH, we'll let you start off with things. What are the pre-action procedures exactly?
Well, the pre-action procedures, action stands for court effectively in that context. So pre-court procedures. So the court has some rules about people just rocking up and starting an application without following some procedures. And those are the pre-action procedures or pre-going to court procedures. And they centre mainly around disclosure and or making a genuine attempt to resolve the matter before you knock on the door of the court. Now, it's designed to keep people out of the court system. It's not a pleasant system to be in. It's expensive. It's extremely long if you're in there from start to finish. So we often say to our clients, if we do the pre-action procedures correctly, we can hopefully keep you out of court. But of course, the other side has to comply. So it's the steps you need to go through before you can contemplate going to court.
Absolutely. And Charlie, what would you say? What are the key requirements that you need to really tick off here?
Yeah, I guess there's a few requirements, and they're detailed in Schedule 1 of the Federal Circuit and Family Court of Australia rules. So the first requirement is a simple one. It's basically both parties need to read the pre-action procedures. So the initiating party will need to provide the other party with a copy of those pre-action procedures. So there's a separate set of procedures for both parenting and property matters. They do tend to overlap. One of the procedures is to invite the other party to participate in dispute resolution, provided that it's safe to do so. And for parenting matters in particular, this will involve obtaining what's called a family dispute resolution certificate before being able to file a court application. There are some exemptions as well that apply, which I'm sure we'll get to at some point. If dispute resolution doesn't work and it's not successful, then the next step would be to send the other party what's called a notice of intention to commence proceedings. So that's, I guess, a more detailed formal letter where one party needs to set out the basis of their claim, provide the other party with a notice of intention to commence court proceedings. And then obviously there's also the need to comply with the duty of disclosure, which we've spoken about at length on this podcast, but essentially both parties need to comply and exchange all relevant documents where relevant.
Absolutely. I know you mentioned some of those exceptions. I'll sort of touch on them now so that we don't forget about them. Really, when it comes to, I suppose, in parenting proceedings, if there's any allegations of, child abuse or family violence, or if there's any risk of those things, would certainly be up there. Same thing in relation to financial or property matters, because it creates a power imbalance between the parties. It becomes very, onerous and nigh impossible for someone who is a victim of family violence to be able to to meaningfully negotiate on their own behalf. And if you're in a really urgent situation, a matter that really requires time, time being of the essence, and you need to get court intervention involved ASAP, that would also be another exception. But there are also other types of matters that don't necessarily require them either. And I think the hallmark example would be an application for divorce, which is just simply two parties who are married, or just one person who's making the application, and they want to go ahead. They've been separated for 12 months and they want to change their marital status from married to single. So that would not require pre-action procedures. That simply just requires, firstly, that you're married. You got to be married before you can apply for a divorce, and also that you've been separated for 12 months. So these are, in general terms, what the pre-action procedures are. We'll then turn our attention to asking the umpire. Yes, you weren't here last time, SH, when we debuted Ask the Umpire. What did you think?
I'm impressed, guys. I love it. I like being the umpire. So.
You look good in the picture. You're looking very sharp.
Yeah, I'm looking about 12 or 20 years younger too. Can I just say one thing, Joe? Just the other exception under the pre-action procedures is consent orders. So if the parties have their own agreement and they don't wish to fight about it or have a battle in court, they can resolve their matters by way of consent, and consent orders bypass the pre-action procedure requirement, and they can go straight to the court portal with that type of application, and if deemed appropriate by a registrar of the court, then those orders can be made, and there's no requirement for mediation or no requirement for to actually work through the pre-action procedures.
Yeah, good pick up there. Where there is no dispute and the parties are in agreement, absolutely. There's no issue for those. So in this one, where you might have seen last week, Charlie and I are both going to ask you one question, and would love to pick your brain here, and I'm sure the viewers would love to hear from you. So I guess I'll start off. Do you still have to comply with these pre-action procedures if the other party refuses to participate at all?
The bane of our existence, Joe and Charlie, where it's always our intention that our client comes to the court with clean hands, and that means that they provide full and frank financial disclosure. If the other party doesn't comply, to be honest, that's not really our problem or our client's problem to some extent. Ultimately, if the matter is before the court, such information could be obtained by way of subpoena if somebody is refusing to provide their financial disclosure. But yes, the obligation is for both parties, and now the obligation is actually enshrined in the Family Law Act, and it moves beyond just the rules. And that obligation is each party in any family law dispute needs to make full and frank financial disclosure. Standard disclosure is tax returns, superannuation statement, pay slips, bank account statements. People love that. The last 3 years of their bank account statements. Oh, why do I have to provide that? He hasn't provided his, or she hasn't provided hers. Well, we can only be responsible for our client and by abiding by the rules and regulations of the court.
And
so the obligation is for both parties.
Yeah, this kind of, I guess, stems on from Joe's question a bit, St. John, but when have you done enough to comply with the pre-action procedures? At what point have you done enough?
Yeah, good question. Some would say never. Federal Magistrate Walters, as he was then some years ago, was known to have said, give and give till it hurts. The obligation, it doesn't stop when you separate, it's ongoing. You have to provide historical information during the relationship and post the relationship. If you're in the court process and it takes 2 years for your matter to be heard, well then all your information needs to be updated to the date of the final hearing, because the court can only make, or will only make, orders based on current financial information. Does that answer
Yeah.
your question?
It does, yeah, and I think it's a good point you raised that it's ongoing because, for example, we have long-standing clients and circumstances change. Clients might lose their job, or they might get a promotion, or receive a redundancy
Or win
payments,
Tats Lotto? Or...
win Tats Lotto, get a big payout on a multi. So, yeah,
Sell a truck.
Yes, yes.
So all relevant to the duty of disclosure, Joe.
Absolutely. And now we turn our minds to fact or furphy. SH, we gave you a couple of questions. It's now your turn to flip the script and give us a couple of scenarios. You got any in mind?
I have. I'll start with you, Joe. Now, fact or furphy, pre-action procedures, so pre-court procedures, apply only to the person proposing to file their application.
No, that is a furphy. That is a furphy, and you did very well to explain that when you were giving the breakdown before. This is a duty that is certainly required by both parties in order to take genuine steps to resolve their matter and to reach resolution. It really is, and it extends to their lawyers as well. Both parties have an obligation to try and mitigate loss and to try and come to an agreement as quickly as they can. It serves a couple of bonuses. You know, firstly, you get to keep out of court. The court is always very busy. It's always inundated with cases. It will never catch up. So eases the burden on the court, and at the same time, it gives people, everyday people, mums and dads, husband and wives, or same-sex couples, the ability to be able to negotiate, come to a resolution in what is a much swifter and in a way that is a lot more, it's cheaper, firstly, and they are in control of reaching their own settlement, keeping their eyes on the prize, because, of course, if you have to get to court, then you are, whatever win you have in there, you're also paying for it with increased legal fees. So there's a couple of real major benefits to having to have both parties comply with the pre-action procedures. So it is a furphy that it only applies to one person.
And that's correct, Joe. And that what people might be thinking out there, well, why do you have to make financial disclosure? The idea is to work out what the size of the asset pool is, and that way you can work out what is an appropriate percentage adjustment of the property pool. So without financial disclosure, you can't nail down an asset pool, which is assets minus liabilities, and you can't have any fruitful discussions about a settlement if you don't know how big the asset pool is. Now, Charlie, fact or fiction, fact or furphy? I'm looking at proceeding to court, and I'm going to ask the court to make parenting and property orders. Is it sufficient that I just follow the parenting pre-action procedures, or do I have to follow the parenting and property pre-action proceedings?
No, that's a furphy. So you'll need to follow both, provided that none of the exemptions apply that Joe went through earlier. So you'd still need to, obviously, if you're filing for property proceedings as well, you would still need to send the other side that notice of intention to commence the proceedings, setting out like we raised earlier, those issues in dispute, the orders that are going to be sought if a case is started. Put forth a genuine offer to resolve the matter, and then generally there's a nominated time frame that needs to be put in place. So at least 14 days after the date of that notice of intention to commence proceedings, which is sent through across in the form of that letter. So you would still need to apply with both pre-action procedures.
Absolutely, and
so in a
I know we mentioned
in a perfect world, if there's no in a perfect world where there's no family violence or no urgency, each party should swap all their financial information, sit down, have a mediation, try and resolve the matter, and hopefully avoid going to court. If it doesn't resolve at that point, then one party who wishes to proceed to court needs to let the other party know of their intention to do so in formal written form, and then and only then can you legitimately make application to the court.
Yeah, exactly.
Yeah. Exactly right. Yeah, and we know it's very, it's rare that we are in that ideal world situation where
True.
Yeah, parties do comply with that, but that's 100% accurate. So you need to comply unless those exemptions apply.
Mm.
And I was going to say that the discussion about the duty of disclosure and ascertaining the asset pool, and that's classic step one of every property settlement matter. And we'll have the video, the previous podcast talking about the 4-step process down below. So if you are unaware of what the 4-step process is, please make sure that you head on over and watch that episode after you're done here. We now turn to play on or blow the whistle. Gentlemen, here's a fact scenario for you. Nice, short, sharp, and sweet. We see it quite a bit sometimes with various parenting matters. And I want you to tell me whether or not you blow the whistle for a free kick for improper action or whether it's play on. One parent has contacted the other parent, giving them a letter informing them of their intention to relocate with their child, and they're going to do so imminently. That receiving parent then goes and issues proceedings urgently in the Federal Circuit and Family Court of Australia. Did they do the right thing? Is it play on, or do we blow the whistle on that behaviour?
I say it's play on.
Play on to me. Play on to me. It's urgent. It's an urgent issue. It goes to the best interest of the child. So yeah, my view is that's a play on.
And it's going to impact on the relationship of the parent that is not relocating, the relationship that parent has with that child. So this is a case in which you could bypass the pre-action procedures. Clearly, it satisfies the requirement of urgency, as you say, Charlie, and it's an application that would be entertained by the court.
Yeah, whether or not you're successful in preventing, whether that parent who is applying would be successful in preventing that relocation is another matter. This is purely just an exercise in determining whether or not the pre-action procedures would need to be followed or not. But the determination will ultimately will hinge entirely really on what is in the child's best interests and whether or not that move is certainly will benefit the child more so than it will having them stay around and be with the receiving parent.
It'll depend on the evidence too, Joe. So if there's a flippant comment like, "Oh, look, I might go and live with my mum in Bendigo," that's very different to receiving a letter from another lawyer saying our client now wishes to relocate to Bendigo. So again, it's going to depend on the type of evidence that's before the parties. But in the scenario you suggested, play on.
Play on, not 15. We then move on to our honest predictions. Honest predictions, gentlemen. We've got 3 games to discuss. The D's versus the Dockers at the G. How do we feel they're going to go, SH? How do we feel about these D's?
I'm looking forward to the ruck contest, to say the least.
Yeah.
Well, I mean, this is they're rucking for the All-Australian ruck position, are they not?
It's the master and the apprentice.
I think the apprentice may have stepped past the master, but we'll wait and see.
He had a master class on the weekend, did the master?
He did. He was incredible. We wouldn't have won that game without Big Max, but...
Yeah, true.
Yeah.
He was rock solid in that last... I thought it was the third quarter, wasn't he, taking those marks?
Yeah, he was. Yeah.
Amazing. He really is amazing for a bloke of his age. He just seems to have eternal energy or eternal youth. It's just unbelievable.
It's crazy. It's crazy.
Touch wood. Oh, touch the wood and touch the wood.
Touch the wooden spoon. I see you holding that, Joe. That's good. Good to see you. Kept your grasp on it.
Not letting go of Harry. He's out.
Well, it is over in Perth, isn't it?
No, it's at the G. It's at the G, but we're coming off a loss at the G last week against Geelong 2 weeks ago.
Poor things. You won about 9 in a row there, didn't you?
We did. We're 9-1 at the G, but I feel like Freo, they'll be keen to prove a point that they know they're going to have to play at the G if they're going to go the whole way. And their forward line is pretty scary, and our defence is probably our main weakness. So
Is Disco likely to be back, or?
I just saw a post that he's a chance. So if Disco's back, we're a chance. If he doesn't play, I don't think we're a chance.
Yeah, that's honest. I'd have to agree with that.
I'm going to say Dockers by 11.
Dockers 27.
I'll say Dockers 17.
Nice. Malcolm in the middle. And then we move to, Jesus. All right. Cardinia Park.
It doesn't get any harder, does it? Doesn't get any tougher.
Cardinia Park, Saturday, 4:35 p.m. The Cats against the Bombers. How much, guys? Let's just move on. How much?
Oh, it's got to be at least 10, doesn't it? 10 goals, at least.
Yeah, I don't think it's going to be near our record-breaking 186.
We're starting 10 goals behind already, SH.
Yeah, I don't know. You weren't that bad against, was it Adelaide? Yeah. That was only 10 goals, and you were playing them on their home turf.
No, it was at Marvel.
Oh, that's right. No. All right. I'm going to make it 15 goals then. Yeah. Honest opinion.
Yeah. I said 88 last week for Adelaide, so I'm going to go 100. I'm going to go 100. Because you guys don't want to win, so just throw in the towel. And also, we've lost by 186 down there, so 100's not that bad.
And I don't think we've won down there for 186 years. So, no, that's not true. Not completely true, but very rarely for 186 years.
Sorry,
no, they're hard mob to beat down there.
That ground is not regulation, I swear. All right, and we then move to your gentlemen. Off a win, the highs of a win, Crows versus Tigers at Adelaide Oval. All three of our games are at Saturday in quick succession, which is pretty funny. Bang, bang, bang.
Get them
back to
over
back.
And done with.
Yeah.
Look, I'm going to resist the temptation to take the lid off or suggest the lid's off, but no. Look, in reality, West Coast. And I know bad kicking's bad football. That's you always use that phrase when you win, but when you lose and you've had a bad kicking day, it's like bloody hell. No, we will get flogged. We will get flogged. We will get done by at least 66 points.
Oh, 66. That's our loss. Not 67, maybe?
Not 67, no. No, I think Look, it's the Tigers. They'll just fall away one quarter and get blown away, and then that'll be effectively the difference with the winning margin.
Yeah, I reckon the Tigers will come out of the blocks hot, and you'll kick the first 3 goals of the game.
Sounds familiar, yeah.
And then I think Adelaide will kick the next 15. And you might lose by 72 points.
Okay.
I'm going to say
we only kick 3 goals for the game.
You might kick a couple more after that, but not many.
Yeah. Put Lawler down for 3.
Yeah, no. I'm going to say Crows don't need to try hard on this one. They're at home. They'll be up and about. They don't want to risk injury now. We're getting closer to the end of the season, so I'm going to say Crows by 48 points.
Well, the 3-headed monster will be back as well, Lonnie. Fogarty will be back, and Phil Thorpe.
All right, I'll change it to 128. No, I'm just joking. No, I'm just joking. No, I'll stick with 48 there. And gentlemen, that does us for this week. Thank you so much to the both of you, as always, for fronting up for yet another fun episode. I thought it was really good.
Thanks, Joe. It was good fun. Yeah, enjoyed the new format.
Excellent, and we hope our viewers enjoy it as well. If you like what you had to see or hear from us today, please make sure that you like, subscribe, and hit that notification bell to not miss out on any of our regular episodes as they drop every single week. And if you are listening to us on Spotify, we would greatly appreciate it if you rated us 5 stars. All these little things, they're small, they're free, they're easy, but they go a long way to helping our outreach and to be able to continue to demystify family law to the general public. And we look forward to seeing you all in the next one. Bye for now.
Bye-bye.